Hey, thanks for joining me and welcome to today's lecture on what we call alternative dispute resolution, also known as ADR. In our legal system, ADR methods offer alternatives to traditional litigation, so going to court, for resolving conflicts. Now, today we're going to explore some of the different forms of ADR and their advantages. So let's dive in. Some of the primary forms of alternative dispute resolution include things like mediation, arbitration, negotiation, conciliation, as well as collaborative law. Now, each method has its own unique characteristics and benefits, which we're going to be exploring in this video. The first ADR method we're going to explore is what's known as mediation. Now, mediation involves a neutral third party, who is known as the mediator, who assists the parties in reaching a mutually acceptable resolution. Now, mediation is completely voluntary, it's confidential, and it really allows the parties to maintain control over the outcomes. The advantages of mediation include the opportunity for open communication, the exploration of creative solutions, as well as the potential to preserve relationships between the parties involved. Next, we're going to explore arbitration. Now, arbitration is a more formal process involving, again, a neutral third party who is known as the arbitrator or panel of arbitrators in some cases. And this individual or these individuals are going to review the evidence and they actually make a binding decision. So arbitration is often used when parties have a pre-existing agreement that requires disputes to be resolved through arbitration. Its advantages include a more streamlined process, flexibility in choosing the arbitrator, and the finality of the decision that binds all of the parties involved. Now we're going to explore negotiation. Now, negotiation is a direct and informal process where the disputing parties engage in discussions to find a mutually acceptable resolution. Negotiation allows for flexibility, creativity, as well as control over the actual outcome, and it encourages direct communication between the parties, potentially preserving relationships as well as reducing costs. Next, we have what's called conciliation. Conciliation is very similar to mediation, but involves a more active role for the conciliator. The conciliator works to identify common ground, propose solutions, as well as facilitate agreement between the parties. The advantages of this method of ADR include the conciliator's expertise and guidance, which of course helps potentially reach a resolution much quicker, as well as the opportunity to help maintain control over the outcome by the parties involved. The next method of ADR is what we call collaborative law. Now, collaborative law is a voluntary and cooperative approach where each party is represented by their own attorney. The parties and their attorneys work together in a series of meetings to find mutually acceptable solutions. And the idea behind this is its goal is to foster open communication, emphasizing problem solving and allowing for a more customized approach to creating solutions. If this process ever fails, the attorneys withdraw and the parties may then pursue litigation. Now, lastly, there are a couple of other notable ADR methods that are less common but still available options, and those include med-arb as well as summary jury trials. So I'm going to start by explaining med-arb. Med-arb combines mediation and arbitration, and so it gives parties the opportunity for a voluntary agreement, but ensuring a binding decision if mediation fails. Summary jury trials incorporate elements of a trial, allowing parties to present their cases before a panel of jurors whose decision serves almost as a basis for settlement negotiations, but it's important that this decision is non-binding. And so it really gives parties sort of a preview for what they would experience if the case was to go to trial, and it can help avoid a very lengthy and costly trial process. Now that we understand some of the different options for alternative dispute resolutions, I want to explore the advantages of ADR over traditional litigation. ADR is often a preferred method of addressing disputes by businesses because it offers greater flexibility, cost savings, as well as privacy. ADR promotes active participation, fosters cooperation, and ultimately allows the parties to maintain control over the resolution process, whereas a traditional court system, or litigation rather, is going to create a binding solution. They are very public, and that may not be in the best interests of the parties involved. These methods are oftentimes also less adversarial, more efficient, and they can be tailored to the specific needs and interests of the parties involved. All right, that concludes this lecture on alternative dispute resolutions, as well as the advantages of each of those methods. The one thing that I want you to remember is ADR provides viable options, or alternatives rather, to traditional litigation, offering pathways to resolution that are more efficient, more collaborative, and ultimately more satisfying for the parties involved. Thanks for watching.